Good evening, everyone. So glad you could join us this evening. My name is Michelle Lyday. I wanted to welcome you to tonight's presentation, Do You Know Your Rights Under the Montana Constitution? This is the sixth installment of the Montana State Bar Citizen Law School, and we welcome you. Have you ever wondered what is so special about Montana's Constitution, or maybe what protections it offers you? Tonight, you'll walk away with the answers to those questions and probably many more. And as luck would have it, guiding us down the path to those answers is Professor Constance Van Clee. Professor Van Clee has not only mastered her field, but has used her knowledge to effect change. I've followed her work, and I'm so impressed by what she's been able to accomplish thus far in her short career. Professor Van Clee is an assistant professor of law at the University of Montana Alexander Blewett III School of Law, where she teaches state and federal constitutional law and appellate advocacy. She has practical experience litigating state and federal constitutional matters and has represented both plaintiffs and defendants in cases raising complex and novel constitutional issues. And prior to joining the faculty at the law school, Professor Van Clee was the founding litigation director of a nonprofit civil rights firm. Before we get started, just a quick note. If you have questions during tonight's presentation, something that you're hoping to get answered, please feel free to use the Q&A function, and Professor Van Clee will get as many as those questions answered as time permits. So without further delay, please join me in welcoming Professor Constance Van Clee.
Thank you so much for the very kind introduction. I'm really excited to be here today talking about the Montana Constitution. It is my absolute favorite subject, and so I'm so glad to get the opportunity to talk about it with you. I am going to pull up a PowerPoint, and I am just waiting for the permission to do that. While I'm waiting, I'll tell you a little bit about what we're going to be talking about today. So we're going to be talking about specifically the rights that are available under the Montana Constitution. So when we think about constitutional rights, we tend to think about federal constitutional rights. And there's a reason for that. They're often in the news, they make big headlines. But as citizens of Montana, we also have rights that are provided under the state constitution as well. I'm wondering if I can get screen sharing permission. When I click on the share button, I see a sign that says sharing is not turned on. So I am just going to see if we can get that figured out. There we go. All right, now you should be able to see the PowerPoint. Now, thank you for bearing with me. So as citizens of Montana, as people who are engaging with Montana government, we have two sets of rights to keep in mind. We have those federal constitutional rights, the First Amendment, freedom of speech, some constitutional rights that are really familiar to us. And then we also have rights under our state constitution. And some of these are kind of gaining in visibility right now. We'll walk through a few of them. I wish we had time to talk through all of them, but there just isn't enough time in a short hour. I'm currently teaching Montana constitutional law at the law school, and we are spending about 2/3 of the semester talking about the unique and sometimes overlapping rights that are afforded under the Montana Constitution. So we'll do kind of a sneak peek and not quite the deep dive that I would really love to do. But you can get a sense of what's unique about the Montana Constitution, how the Montana Constitution provides different rights than are available under the federal Constitution. And so to just go over what we are going to be talking about today, we're going to start with the concept of popular sovereignty. And I'll explain a little bit more about what that is. But the word sovereignty refers to the sovereign, traditionally, the king of England. Popular sovereignty is the idea that's baked into the Montana Constitution from the very beginning, all the way through, that as the citizens of Montana, we are the sovereign. We are fundamentally, ultimately in charge, not the government, not the governor, not the King of England, but the people are the popular sovereign. And that is who our Constitution exists for. I'm going to talk about powers. And in constitutional law, when we use the word powers, we're really talking about structure of government, the way in which our government is built to enforce our rights, how we can use the different branches of government in order to enforce our constitutional rights. And then I'll talk about just a handful of the unique constitutional rights afforded under the Montana Constitution. And then it is my hope to have some time left at the end to answer questions. As Michelle mentioned earlier, if you have a question at any time, go ahead and put it up in the Q&A box. I'm going to try to monitor those throughout the presentation, take a look at the Q&A box at different times, and then ultimately get to the things that I think would be really helpful to address at the end of the presentation if I haven't had a chance to do that before. So what is even in the Montana Constitution? A whole lot. It is roughly as long as the US Constitution. And what I have listed here is just the table of contents, essentially, how the Montana Constitution is structured. So when we think about rights under the federal Constitution, we're talking about amendments. We're talking about these provisions that were amended. The Constitution was amended to include individual rights provisions because the US Constitution, as it was initially drafted and ratified, did not include the right to free speech. It did not include the individual freedoms that we think about when we think about the federal Constitution today. Our Constitution was written in 1972 after centuries of US constitutional law and a sense of the importance of individual rights within a constitutional framework. So our Constitution is structured really differently. We have the preamble, and I'll talk a little bit more about that specifically. Article 1 is a couple of sentences. It may even be only one long sentence. It's a single provision that explains the relationship between the state of Montana and the federal government. And it expressly incorporates the agreements between the federal government and the Indian tribes existing within the borders of Montana. That's Article 1. That's the entirety of Article 1. Article 2 is the Declaration of Rights. There are currently 35 separate provisions within the Montana Declaration of Rights. There will be 36 in July because that is when Constitutional Initiative 128, which just passed in the most recent election, will go on the books as Article 2. Most of the individual rights, when we think about individual constitutional rights, most of the individual constitutional rights afforded by the Montana Constitution are found in Article 2. They aren't found exclusively there, so they, your rights, your constitutional rights will at times pop up in other places as well. But Article 2 really kicks off the substantive provisions of the Montana Constitution, and it starts with your basic individual constitutional freedoms. Then Articles 3 through 7 are kind of setting up the system of government. Articles 8 through 10 are more specific provisions that have to do specifically with how state government functions. Article 11 is another article that doesn't have a federal analog, because local government is a creature of state law exclusively. And then Article 2 and Article 12 and Article 13 are a little more general and kind of a little bit more disjointed. Finally, Article 14 is constitutional revision. How do we, as the popular sovereign, change the Montana Constitution? And I'm going to talk about that a little bit as well. So I used this phrase earlier on the map slide, popular sovereignty. This is the idea that we, the people of Montana, we are what we are talking about when we talk about Montana. And we see this principle of popular sovereignty permeating the Constitution. It starts right there in the preamble. We, the people of Montana, grateful to God for the quiet beauty of our state, the grandeur of our mountains, the vastness of our rolling plains, and in desiring to improve the quality of life, equality of opportunity, and to secure the blessings of liberty for this and future generations, do ordain and establish this Constitution. Who is establishing the Constitution? We are, the people, the popular sovereign of Montana. And we see that again, Article 2, Section 1, the very first provision within the Declaration of Rights, titled Popular Sovereignty. And it explains this concept of how we, the citizens, the people of Montana, can be what we talk about when we talk about Montana. All political power is vested in and derived from us, the people. All government originates with us. It's founded upon our will only and is instituted solely for the good of the whole. Article 2, Section 2, the very next provision within the Declaration of Rights, explains that the people have the exclusive right of governing themselves, and that the people may alter or abolish the Constitution and form of government whenever they deem it necessary. This means the Constitution rises up from the people, and then ultimately the people are in charge. We are the check on government. We have the ability to change the Constitution. It exists in order to serve us as the popular sovereign. Just a couple of other provisions that really relate again to this concept. Article 5, Article 5 addresses the legislature's powers, the legislature's duties. Even here, where we're talking about what the power of the legislature is, we see a reminder. The people have the powers of initiative and referendum. That means that we have the ability to change the Constitution. We also have the ability at the ballot box to enact statutory law outside of the constitutional process. Article 14 explains how it may be the case that the people would go about abolishing or changing the Constitution. So this is the last article within the Montana Constitution, and it addresses specifically this issue. We have the initiative power, and that is how you can change the Constitution without the legislature taking any action in the first place. This is the signature gathering process. You as a citizen or a group, another citizen can start this process. You can draft language, you can gather signatures, and if there are enough signatures, then a proposed constitutional provision will be placed on the ballot for you and your fellow voters to consider at the next general election. The referendum power is another way in which the citizens get to decide by a majority vote whether to change the language of the Constitution. The difference between the referendum power and the initiative power is that a referendum comes to the voters after the legislature certifies it to them. And it takes 2/3 of the legislature in order to do that. A supermajority of the legislature can agree that there is language that should go into the Constitution, but they don't have the power to put it into the Constitution themselves. They have to submit it to the voters. And then the voters at the next general election decide with a simple majority vote whether or not to amend the Constitution. Finally, we have the Constitutional Convention. And our Constitution came about as the result of the last Constitutional Convention in 1972. And it was determined at that time that the old Constitution, drafted and ratified in 1889, was not serving the people of Montana. The legislature commissioned a study, and the study proposed a new constitutional convention to kind of start over. The problems with the 1889 Constitution were too significant. It wouldn't be possible to just amend it to fix the problems. What was really necessary was to start with a blank page. The legislature submitted the question of whether to call a constitutional convention to the voters, and the voters overwhelmingly approved calling a constitutional convention. And when the framers of our 1972 Constitution got together to write the new Constitution, they wanted to be sure that the people of Montana going forward would remain in the driver's seat. And so we have these different ways in which a constitutional convention can be called. 2/3 of the legislators in the legislature can propose a constitutional convention. But again, they can't do it on their own. What the supermajority of the legislature can do is they can submit the question to the voters to determine whether or not to call a constitutional convention. The voters can also call a constitutional convention by initiative, and this would be a similar process to changing the language of the Constitution or adding new language to the Constitution, where there's a signature gathering campaign. You need a lot of signatures. 10% of the voters in the state of Montana would be required. And if you get enough signatures, then the question goes to the voters, and a majority would decide whether to call or not to call a constitutional convention. Now, if neither of those things happen, there's an automatic provision that kicks in. That's that every 20 years, the question goes to the voters one way or the other. It is periodically submitted to the voters to determine whether or not to call a constitutional convention. So that really gets at this concept of popular sovereignty. How can it be the case that we are Montana as it is used within the Constitution? How can it really be the case that we, the people of Montana, remain in charge of government when we have this vast bureaucracy, different government actors that are doing the work of government on a day-to-day basis? So I'd like to move into the idea of separation of powers. Now, you've probably heard the phrase separation of powers before. When we talk about separation of powers, we're talking about the idea that different branches of government have different unique roles to play, and that they can serve as a check on each other. So the legislature has its role, and it can't do the work of the governor. This starts off Article 3 in the Montana Constitution, explains that the government, just like the federal government, is divided into three branches. We have the legislature, which in Montana, as under the federal constitution, includes both a Senate and a House of Representatives, so two houses that together make up the legislature. We have the executive branch that includes the governor, the agencies, and we have the judicial branch. And the Constitution provides no person or persons charged with the exercise of power properly belonging to one branch shall exercise any power properly belonging to either of the others, unless the Constitution specifically says that they may. So the classic conception is that we have this kind of circle where each of the branches serves as a check on the other branches and can be checked by the other branches. The job of the legislature is to pass legislation and to exercise some oversight over other branches of government. The executive branch, unlike the legislature, is working around the clock all year round, whereas the legislature meets only once every 2 years and only for a period of months. The judiciary includes your county courthouse, trial court, and trial courts do civil work and they do criminal work, and then the Montana Supreme Court, which hears appeals from all of the decisions through the district courts, the trial courts in the counties. And the Montana Supreme Court and the district courts have the job of interpreting the law when it needs to be interpreted. So let's talk a little bit more about the legislative power. The reason that I want to talk about the legislative power when the goal of this session is to talk about constitutional rights is that the legislature has the job under the Montana Constitution of enforcing some of those rights. Often when we think about how do you enforce your constitutional rights, we think about going to court, filing a lawsuit and saying the government's violating my rights. But every branch of government, every government actor has a duty, has the obligation to enforce the Constitution's provisions, which includes individual rights provisions. And I want to talk about a couple of rights that are set forth in the Montana Constitution that that the ball is given to the legislature to enforce these rights in the first place. The first is Article 10. This has to do with education. The legislature shall provide a basic system of free, quality public elementary and secondary schools. Montana Constitution provides a right to a free and quality education. And how is that right enforced? Well, in the first place, by the legislature. The Constitution clearly commands the legislature to ensure that that system of free and quality public schools exists. And you can look also at Article 9, Section 1, which provides that the legislature shall provide for the administration and enforcement of the duty to maintain and improve a clean and healthful environment in Montana for present and future generations. This is the Constitution's clear language, again, saying, legislature, you need to take action here because the people of Montana have an important constitutional right, and it falls on your shoulders as the legislature to ensure that that right can be enjoyed the way that it is intended to be enjoyed under the Montana Constitution. Now, the executive branch, when we're talking about the governor, we're talking about the different departments of government, all of the agencies in Montana, doesn't have the same kind of language directing the governor to implement specific constitutional rights. But the governor nonetheless has the obligation to enforce our constitutional rights, to carry out the commands of the Montana Constitution. And it's not just the governor, it's also the Secretary of State, the Attorney General, the Superintendent of Public Instruction, and the State Auditor, all of whom are independently elected in a statewide election. The governor specifically has the duty of carrying out the laws that are passed by the legislature, and at times taking action when necessary, even in the absence of legislation. And then the final branch of government is the judiciary. And again, we have our county courts, trial courts that hear criminal cases, they do sentencing, and also hear civil cases when somebody sues one another, for example, for breach of contract, or sues government for violation of constitutional rights. The judicial power has long been understood to give the judiciary the ultimate say on contested questions of constitutional interpretation that are properly before the court. And I'd love to point to a specific provision. So on this slide, you see the first provision, which refers generally to the judicial power. Doesn't give us a lot of information about how the judiciary functions, but take a look at Article 2, Section 16. So again, this is found in Article 2 within the Declaration of Rights in the Montana Constitution. And this provision says, courts of justice shall be open to every person and speedy remedy afforded for every injury of person, property, or character. Right and justice shall be administered without sale, denial, or delay. So we as Montana citizens have a right to access the court to hear the cases for which the legislature has provided a remedy. And this provision is really interesting. It's common to state constitutions. There's nothing like it in the federal constitution, and it traces back to the Magna Carta. And it was, leading up to the Magna Carta, a requirement for somebody who wanted to go to court to pay a certain amount of money that depended on the remedy that they were asking for. And one of the rights that was afforded to the freemen under the Magna Carta was the right to go to court without having to pay a toll in the first place, to open courts provision. And that language, going back to the Magna Carta in 1215, has found its way into almost every state's constitution. Okay, now I want to turn to some of those unique constitutional rights that we have under the Montana Constitution. We will talk about the inalienable rights provision, about dignity and equality, about the right to participate and the right to know, and about the right of privacy. And then we will have some time for questions. So inalienable rights. What does this mean? Inalienable rights provisions are common to state constitutions. There's the idea of inalienable rights in the Declaration of Independence, although not in the federal constitution itself. And what this means, inalienable rights are rights that government couldn't even take away if it tried. There's something fundamental to who we are as people, that they exist without recognition, even in a constitution. How to enforce them is a question that has not been conclusively answered. What you see in our inalienable rights provision are some really Montana flavored inalienable rights. The right to a clean and healthful environment, recognizing the beauty of our state as described in the preamble, and the importance of that environment continuing to exist into the future. Also, the right of pursuing life's basic necessities, of enjoying and defending their lives and liberties, acquiring, possessing, and protecting property, and seeking safety, health, and happiness in all lawful ways. The right to a clean and healthful environment, you may have seen in the news over the last year or so, with a case held v. Montana that went through trial in Lewis and Clark County and is currently pending before the Montana Supreme Court on appeal. And that case gets at whether or not the right to a clean and healthful environment means the right to an environment that is not is not degraded by climate change. There's a whole lot of complicated legal issues that are at issue in that case and held, but fundamentally what the plaintiffs in that case are arguing is that their right to a clean and healthful environment means a life-sustaining environment that is not degraded by climate change caused by greenhouse gas emissions. And we're still waiting to hear from the Montana Supreme Court about whether or not the judgment for the plaintiffs will stand. Another part of this inalienable rights provision that has been interpreted in interesting ways is the rights of pursuing life's basic necessities language, and that's been understood by the Montana Supreme Court to provide the right in some way to employment, because you cannot pursue life's basic necessities. You can't have life's basic necessities if you are unable to seek and maintain a job. Turn now to Article 2, Section 4. This provision has a lot in it, so we'll spend a little bit of time unpacking it. It's titled the Individual Dignity Provision, but it also includes our constitutional rights to be free from discrimination. That concept is referred to as equal protection as a matter of constitutional law. The first sentence of the Individual Dignity Clause refers specifically to dignity. And I say specifically because it's focused on dignity, but is really broad language. The dignity of the human being is inviolable. It's never been determined under the by the Montana Supreme Court whether this right to dignity, whether the first sentence provides a standalone enforceable right? Can you just go to court and say, this violates my dignity as a human being? We don't know. The Montana Supreme Court hasn't decided that issue specifically yet. What the dignity clause, this first sentence on the slide in front of you, what the dignity clause is usually understood to be is what's been described to me as a force multiplier for other provisions. So when you have maybe a First Amendment, a free speech violation, and you can also claim a dignitary harm, that it's demeaning to you in some way, or that you've been discriminated against, and in a way that's really demeaning, then the dignity clause might step in to give a little extra kind of oomph to your argument, to show the strength of the right that you are asserting. The second sentence here in Article 2, Section 4 is a general equal protection statement, really mirrors the language of federal law. No person shall be denied the equal protections of the law. This is a general non-discrimination provision. And the reason that we have a general non-discrimination provision is that it is generally accepted that the law works best when it operates equally upon all. So that some people can't use the law in order to, for example, enrich themselves to the detriment of others. We want laws that are kind of generally applicable and neutral, that apply equally to all. The third sentence is really interesting, and it doesn't have an analog under the federal Constitution. Neither the state nor any person, firm, corporation, or institution shall discriminate. And what's unique about that is that it doesn't just apply to the state. Usually when we talk about a constitution, we're talking about a contract between the people and the government. But here, this contract is also referring to other people. So can you sue somebody for discriminating against you? Article 2, Section 4 suggests that individual people can actually violate the constitutional rights of others. In reality, in Montana, the way in which you enforce your right to be free from discrimination against other people is through the Montana Human Rights Bureau. And so there's a remedy that's available that's been set up by the legislature that operates under the executive branch that you can avail yourself of if you've been subject to discrimination, for example, in employment, in housing, or a public accommodation, somebody refused to serve you. And the second half of this sentence is also really interesting and doesn't have an analog under the federal Constitution. So the first part gets at who can violate your right to be free from discrimination. The second part of the sentence says what are different areas in which you have enhanced protections to be free from discrimination. Those include race, and color, both of which are protected under the federal Constitution. Sex, which is protected under the federal Constitution, but not as strongly as race and color. Culture, social origin or condition, or political or religious ideas. There are protections against religious discrimination under the federal Constitution, but culture, social origin or condition, or political ideas, these are all concepts that are really unique to the Montana Constitution. like to talk about the right to participate and the right to know. So this slide focuses on the right to participate. The next slide focuses on the right to know, but we often think about these provisions that go hand in, or as going hand in hand. And these provisions also relate to that idea of popular sovereignty, because they're ways in which we, the people of Montana, can take part in government, can exercise oversight over government, that are something different than just being able to vote at a regularly scheduled election. So the right to participate is found in Article 2, Section 8. The public has the right to expect governmental agencies to afford such reasonable opportunity for citizen participation in the operation of the agencies prior to the final decision as may be provided by law. A lot of words and kind of a complicated sentence structure. But what Article 2, Section 8 does is says that government really needs to be open to the citizens. And where we see this a lot is in agency proceedings, for example, the Department of Environmental Quality, DEQ, when it's looking at whether or not to issue a permit to a specific project. We also see it in local government. And local government has to, pursuant to this constitutional provision and our broad right of participation, has to allow citizens to be engaged in local government. So what I've got posted here on the left side of this slide comes from the City of Missoula website. And it is information. You can go on the website. It's surprisingly easy to find. And that's true of most of the major cities in Montana, a little bit harder for some of those smaller jurisdictions that don't have the same kind of website budget that the larger cities do, but really easy to go onto the website and find information. What's your schedule? When is the city council meeting again? How can I participate? Can I go in person? Will it be held on Zoom? You can find that information. And you do have the right to comment on pending matters. You have the right to ask questions. You do have the right to participate really broadly. And the local governments have, for the most part, understood their obligations under Article 2, Section 8, and demonstrated a commitment to making their proceedings open to the citizens. Now, a corollary to the right to know, right to participate is the right to know. And the right to know provides, it's a little bit different. So the right to participate is your right to be engaged in governmental processes before the government reaches a final decision on something, your ability to influence or to at least attempt to influence the work of government. The right to know is really a right of oversight. No person shall be deprived of the right to examine documents or to observe the deliberations of all public bodies or agencies of state government and its subdivisions, except in cases in which the demand of individual privacy clearly exceeds the merits of public disclosure. So the right to know means that you have the ability to ask for documents from your government, for the government to, and the government is obligated to provide them for you, except for in this circumstance that there are individual privacy interests involved. Now, there are some other exceptions. They have been narrowly construed. However, for example, communications between a government agency and its lawyer relating to litigation is deemed privileged, and that wouldn't be subject to the right to know. For the most part, Article 2, Section 9 is exactly what it says it is. You have the right to documents. You can ask for them. They have to give them to you unless there are important individual privacy interests at stake. So what I've got pulled up here is the Missoula County Public Records Request Portal. Similar portals exist for most of the larger counties, where if your county or city government, whoever you're seeking documents from, they don't have this kind of website, they don't have this kind of opportunity that really tells you how to go about doing it, should be able to call somebody in the clerk's office and they'll be able to tell you how to fill out an information request. It is the case that they can charge under the statutes that have been passed by the legislature, they're allowed to charge some amount of money to access these documents. They're supposed to be tied, any fees that are charged are supposed to be tied to the actual cost of producing the documents to you as the citizen. But it's something to keep in mind, because if you want to exercise your right to know, you want to request some documents, you'll want to think about how to make your request fairly narrow so that you're getting a discrete set of documents instead of a really broad request that's going to take them a long time to respond to, that might include a lot of documents that you aren't actually needing or wanting, because that's going to drive up the cost. Generally, if you submit an information request and it's going to cost money, you will hear an estimate of it, and you'll have some opportunity to adjust the request to bring those costs down. So one more unique constitutional right to talk about, this is the right of privacy. If you remember on that last slide, the right to know refers to documents in which there's an individual privacy interest. And the reason for that, the reason that that language is there, is because the Montana Constitution is deeply solicitous of our privacy rights. And the Constitution's framers were deeply concerned about state interference with the right of privacy, which they referred to as the right to be left alone. They were particularly concerned about, and remember, this is 1972 that our Constitution was drafted. In 1972, the delegates to the Constitution were particularly concerned about advanced technology. And it may seem even a little quaint to think about what advanced technology was in 1972. But I think it was very, the delegates had their eye on the future. They were worried, for example, about wiretaps. They were worried about recordings. One would expect that they would be deeply concerned about the far more advanced technology that exists today. So the right of privacy exists to give each of us a kind of protective bubble around us. The right of individual privacy is essential to the well-being of a free society. If we want to have our freedom, we need to have our privacy. You can't have liberty if you don't have privacy. And the right of privacy shall not be infringed without the showing of a compelling state interest. And when we talk about the right of privacy in constitutional law, we talk about two different concepts. The first is what we call informational privacy, and that's the wiretap. That's the recording. That's the requirement that the government get a search warrant before it go through the items in your house, right? Or that's the right to control information about you. to prevent the state from having the ability to access that information whenever it wants to. The other aspect of the right of privacy is what we call autonomy privacy. And that is the right of the individual to make deeply personal decisions about the individual's body, about the individual's choices in life without the government getting involved in the first place. So it's that autonomy privacy that has been understood to protect, for example, reproductive rights, the right to abortion, which was recognized by the Montana Supreme Court under this provision, Article 2, Section 10, even before CI 128 passed in the last election. The right of privacy has also been understood to prevent the state from criminalizing same-sex behavior. It's these deeply personal decisions that people make, their ability to control key aspects of their life without the government interfering. That's autonomy privacy. So again, the right of privacy encompasses these two different concepts: informational privacy, searches and seizures, right to say no, get a warrant, that's informational privacy, and then autonomy privacy is the right to be in control of your body and decisions about your life. And that is it for the specific provisions that I want to talk about. And I just want to introduce really briefly, well, okay, so you have a right. Does that mean that the government can't ever interfere with the right? And the answer is no. No right is absolute. That's the idea. No right is absolute. So what courts do is they determine whether or not the government is justified if it interferes with or infringes your right. And the burden that the state needs to meet in order to show that it is in fact justified really depends on the strength of the individual right that is asserted. So those rights that we find in Article 2, currently 35 different provisions, soon it will be 36 different provisions. They're subject to what we call strict scrutiny. You probably heard that phrase at some point before. This is the hardest burden for the government to meet. They have to show a compelling state interest. It's not just like a squint and you can see it kind of state interest, like, it seems okay. It's not just a good state interest. It has to be compelling. It has to be really, really strong. And whatever the law is, it has to be narrowly tailored to that compelling state interest. So the provision, the law, has to advance exactly that compelling state interest, no more and no less. Now, rights that are outside of Article 2 are subject to intermediate scrutiny. And it's still pretty hard for the government to satisfy intermediate scrutiny, but not nearly impossible the way that strict scrutiny is. You need a reasonable state interest. It has to be good, it has to make sense. And it has to outweigh the burden on individual rights. It has to be a stronger interest than the individual has. And then finally, other rights, things that aren't in the Constitution exactly, are subject to rational basis scrutiny. This is the lowest level of constitutional review. The state needs to show a legitimate state interest. It has to be rational. It has to, this is the, you squint and you can see it kind of state interest. And there has to be a rational relationship between the state interest and the law. All right. So we have a little bit of time for questions. I have some questions in the chat box, and so I'm going to go through those. Please feel free to ask questions there, and I will talk about them. So I have a question here about the relationship and the relationship between the Constitution and the Montana Code annotated. How do they coexist? How are they different? So the Constitution is the highest law, and anything that's in the Montana Code annotated has to be consistent with the Constitution. So the Constitution provides the baseline, the floor, and the Montana Code cannot go beneath that floor. It needs to be consistent with the Montana Constitution. The Constitution includes two broad sets of provisions. There are the provisions that set forth the structure of government, and so the laws in the Montana Code have to be enacted and enforced consistent with the Montana Constitution's provisions governing the powers or structure of government. And they also have to not interfere unduly with individual rights. So a law that infringes one of those fundamental rights found in Article 2, the legislature can pass it, it'll go on the books, but somebody challenging it will be able to say that the state needs to satisfy that strict scrutiny test. Otherwise, the law may be held unconstitutional. And you see examples of laws that have been held unconstitutional that still show up in the Montana Code annotated. For example, under the Montana Code annotated, the marriage is defined as including only heterosexual marriage. That provision has been deemed unconstitutional as a matter of federal constitutional law. It can't be enforced. The state can't enforce it because it violates those federal constitutional rights. It still shows up on the books unless and until the legislature repeals it. I'm going to answer a couple of questions that have to do with the constitutional revision piece that I talked about. So those two questions are about CI 128, the new provision governing abortion rights, an express right to a pre-viability abortion under the Montana Constitution, and a question about how careful should we be about amending the Constitution? Because I think they kind of go, well, they relate to each other. So first, with regard to the specific question about CI 128, could it in the future be taken away? Yes. Either the legislature by a referendum, so if 2/3 of the legislators voted to refer the question to the people, it would be placed on the ballot. And so the legislators might, again, it would take 2/3. So this is 100 total of the 150 state representatives and state senators in Montana. If they passed this bill, it would go on the ballot and the voters would then choose whether or not to repeal this express constitutional right to an abortion. So that's one route. The other route would be through signature gathering. So just as the proponents of CI 128 did, they came up with the proposed language, they gathered signatures that made it onto the ballot. Proponents of a new measure seeking to repeal CI 128 could do the same thing. There's no provision in the Montana Constitution that is not subject to revision. And that includes those that are passed through initiatives, no matter how recent. Now, if CI 128 was in fact repealed by initiative, it would be the case that the Montana Supreme Court would have to decide whether to rethink its precedent on the right of privacy and that autonomy privacy, because those cases have not been overruled. And so it is still the case that the Montana Supreme Court's most recent decisions about abortion determine that there is a constitutional right to abortion under the right of privacy. And the other question is about sort of how careful should we be with amending the Montana Constitution? And there's not a really clear answer about it. It's really hard to amend the federal Constitution. So hard, in fact, that our Constitution is the hardest to amend constitution, the functional constitution in the entire world. And there's a reason for that, right? Our Constitution was kind of an experiment. And later constitutions saw what the American Constitution did, took a lot of things that they found to be really great ideas, but also made it easier to amend them in the future. So there's an argument the constitutions should be relatively easy to amend because otherwise these issues go to the courts and they're better off in the hands of the people. And the people should be able to make sure that the Constitution remains a modern document. And the other side of it is the constitutions get really messy. They include conflicting provisions, and what a constitution really should be a set of big picture principles that everybody agrees to live by. And if you get too detailed, then you lose that sort of the nature of the Constitution itself. I am out of time.
You did such an amazing job, and there were such good questions. I know that it was hard to narrow them down. I hope that everybody took away from this something that they didn't know before. And please help me in thanking Professor Van Clee for joining us this evening, for conveying to us such important information from her level of expertise. And I really hope that in the future you're able to join us again. There is another, I believe, two more sessions. So sign up for those two additional sessions of the Citizens Law School. And again, thank you so much. And thank you so much, Professor Van Cleve. That was a great deal of information that you conveyed in a very real way that we all understood.
Thank you for having me. It was really fun.